DACA goes into effect. USCIS remove barrier for applicants with disability. Those are the immigration news this week. My name is Annie Koloko. I am an immigration attorney, and welcome to Koloko Immigration Channel, where we strive to inform you about immigration and also whether it's change immigration law or actually immigration news and things that you should know. Now, don't forget, very important, don't forget to click the channel and to join. That way you will receive the notification and you will not lose a bit. Now, let's do it. Now, like I say, obviously, the Biden administration DACA rule goes into effect. Now, what happened? DACA is actually a rule that was actually implemented under the Obama administration, meaning this has been going on for a very long time. However, the reason also though we're talking about this new rule is because since the end of the Obama administration, this particular rule have been in the object of several litigation, right? Meaning that some litigation, it went all the way actually to the court, the federal court, and there we are. Now, you may be thinking, what is DACA? For those of you who don't know about DACA, DACA actually protect people that were brought in the country. You probably know them also as dreamers. They were brought to the country as children, right? And either they crossed the border with their parents without any legal status, or maybe they fell out of status, right? Now, the reason this is very important because these young people, have not known any other country than the United States. And under the Obama administration, then it was actually unfair that they will live into the shadow. And the whole actually argument and the litigation is because it's that two different current, right? Where some part, obviously in the country, because you have two different view of this, believe that, okay, that these young people deserve actually to have a path towards citizenship, as opposed to certain who definitely do not share that same point of view. That's the litigation. Now, the thing is, what happened with DACA? DACA was challenged into the court, and you have to remember that when it went into effect at the time under the Obama administration, he was actually created from a memorandum, right? Meaning the Department of Homeland Security, which is the agency actually, obviously that prepared this particular memorandum, on the instruction from the administration to Obama administration. At the head of the agency, that was former DHS Secretary Janet Napolitano. And she actually, obviously her agency created this particular memorandum, codifying, explaining, exactly giving the requirements, obviously, of to whom DACA will be applicable. Now, the technicality, because there is always the devil, is in the detail. How were the challenge mounted against this particular rule? It was actually, you have to remember that the rules that goes through an agency, the rule-making process requires notice and comments. And that's the part that was actually missing, meaning that given that the rules were enacted, codified by the Department of Homeland Security, it should have been followed by actually notice and comments. This is basically how it goes with USCIS, right? You see USCIS, it goes through it like there is a rule. Even if, for example, there's an increase, a fee increase, then you will see that it will be published, inviting actually the public to submit what is called notice and comment. And this is exactly what was missing in this particular case. And that was the technicality that actually was the legal basis of this litigation challenge. Now, he went in front of the federal judge, that was Judge Hannon, right? And Judge Hannon actually agreed that that he was missing, that the point, brought by the litigant was actually valid. But he did add, a little bit of a wrinkle here, a little bit of a reprieve from the administration by saying that, yes, the program could continue temporarily while they will be litigating, obviously, to see whether the program will cease to exist altogether. But on one hand, although the program could continue temporarily, that will be for people who already have a DACA status, meaning that it will not allow new applicants to submit DACA application to USCIS. That's basically what's happening here, meaning the new applicants are barred from applying for the moment, right? And you will see that when we're talking about the DACA new rule under the Biden administration, is basically an effort by the administration to fortify, really to make sure that to solidify this particular, obviously this particular rule. And that's what they're trying to do. And that has come into effect. It's not very different from the one that was actually enacted during the Obama administration, but they just wanted to have all this legal protection, right? But at this point, that's for the moment. Judge Hannon, the federal court, when he went in front of Judge Hannon, and then Judge Hannon ruled, like I explained to you guys, that the program could still continue on temporary basis while they will be going, obviously they will be reserving the right until the matter has been heard fully, right? Now, obviously, the administration filed an appeal, and it went all the way to the Court of Appeal. And the Court of Appeal actually agreed, right? They agreed, they agreed, and they sent back the case to Judge Hannon and actually asking him to review the administration rule. Meaning that basically that's what exactly this is happening. That's why for the moment, the rule is ongoing as far as applicants that are already in the pipeline, already in the system. But if you are a new applicant, unfortunately, at this time, you cannot submit. You will have to wait until he has been fully litigated. And now, finally, just to give you an idea, what is DACA? What does that do? Once you have DACA, you are allowed to work. Legally, you will have your working permit, which is extremely convenient because that was a huge issue with these young people that would be coming of age. And then obviously, going through the system, graduating, for something and entering to university, going to college and be unable to do so, even be eligible for either grant or not even grant, but actually federal, obviously federal loan and things of that nature, right? But at least now we're having this legal status that protect them from deportation, which is huge. And they have a work authorization, at least they can come out of the shadow. And I think what the administration is trying to do is actually to see how to really render this permanent and then go from there, from them to get out of the shadow and create a path towards citizenship. But this is to be continued because when we talk about immigration, it's always extremely, polarizing, it's extremely political, meaning that we don't just, we will keep you posted because obviously it can change. We'll see once we have actually a ruling from Judge Hannon and see whether the DACA rule will actually survive such litigation. Now, we are going to, obviously the next subject that we wanted to talk about your immigration news is the fact that USCIS is removing naturalization barrier for applicants with disability. And this is very, very important. In my practice, I've seen a lot of applicant disability, most of the time is underrepresented community, people of color, that find themselves, and sometimes even people of color, people with disability that found themselves struggling to overcome this barrier that was actually required once you submit an application for citizenship. And now you have to understand that as part of the U.S. citizenship process, it does require applicants to pass a two-part test, meaning when you go in front of the officer, you have to pass a test in English, right? Proof of the English language, and then the other one that will be the civic knowledge. Obviously, if you have a long-term medical condition, then you can ask for an exemption. But where there was a wrinkle is that when you ask for exemption, the form that goes with it, which is the form N648, is medical certification for disability exception. That form has to be completed by a medical professional. The issue where there was some issue is that sometimes the question were quite burdensome, and some medical practitioners were not really, it was not very encouraging for them, really to proceed through this, and that required to have a certain relationship with the medical practitioner over a certain period of time. And sometimes you have some clients, some people, applicants for citizenship who maybe don't even have, probably the mean they don't have this relationship, maybe they don't have access to medical treatment, meaning they may not have developed that, and that render actually the completion of the form by the practitioner quite difficult. Now, those are the revision on the form, and I found it really great because I really remember clearly this being a huge issue. Like, we work with the client, but the part where as attorney we cannot overcome that is when we send the client now to the doctor and asking the doctor to complete the form. And sometimes that will be a problem. Either the form will be either the question will be very vague because the medical practitioner maybe don't have all, or maybe there's some information that may are missing. And then USCIS will be rejecting the form because they see that it is not specific enough, things of that nature. And that was a huge issue. And it's really, quite interesting, and it's a good news to see that those barriers have been actually removed. And these are the revisions that you will see on the form. Now, the date of obviously, let's start with the first one, right? All redundant questions are removed. What do they mean by redundant question? Redundant question, it means that the question that happened and then they are asked on the different form. That has been removed. And why is this important? Because you have to remember, medical practitioners are very busy, right? They have huge practice, volume, and they don't have time to sit down and actually answer the same question more than once on the different form, meaning those redundant questions have been removed. Now, the date of diagnosis requirement have been removed as well. For example, somebody who has a medical condition, the medical practitioner will not have to, because when they say the date of diagnosis, the issue is obviously to go back in the patient history, and the patient may have probably a diagnostic that is dating several years back. Maybe the medical practitioner was not even the one who made the initial diagnosis. Maybe the person even moved out of state. They may not even have access to the medical record. The time to order all of that may actually prove to be an hindrance. And that's where it could be an issue. But now, if the date of diagnosis requirement removed, it means that the medical practitioner completing the form will come to the diagnosis by him or herself. See, this is why it's actually very convenient. The next question also that have been removed for the form is the disability severity description requirement removed. This is also, we don't have to get into this full analysis, right? Because this was also one of the questions that was the object of refusal over and over again. They were asking, USCIS would be asking the medical practitioner to describe the disability and its severity. And obviously, sometimes the practitioner will just maybe write one sentence or two sentences, and that will be deemed insufficient in the eyes of USCIS, and then the form will be rejected, and then we get back to square one. At least now that's gone. Now, one that I found very interesting, the medical professional previous relationship with the applicant requirement has been removed. This is also very important because sometimes the question was there, like for the medical practitioner to describe their relationship, aka how long have you been treating this patient, right? And the idea being you have had to have treated the patient for a significant amount of time in order for you to have a diagnosis. Not necessarily. Just as a medical practitioner, he or she have actually the competency to pass a diagnosis of a patient, right? And this, by removing this particular question, that actually is extremely helpful. And also, finally, there's also an option to include telehealth medical examination. This actually comes, in the obviously the COVID era, where now telehealth become quite the norm. Meaning that if you're not able, let's say, to have access to a practitioner, next to you, near you, for some reason, or maybe you still have, you're still actually seen by your own medical practitioner, but maybe is not in the same location as you are at this time, at this moment, you have this option to have a telehealth medical examination, and that will come to a diagnosis. Meaning this is actually very important, because you can see that the administration is purposefully, choosing this, to remove all these barriers, because they definitely, I guess, noticed that it was disproportionately affecting and underrepresented, obviously, some actually segment of the population, like I say, people with disabilities, sometimes people also affected economically, people of color, meaning they really want the process to be smoother and actually more accessible. Meaning those are the two news I wanted to touch base with you about. I wanted you guys to know about it, because this is something extremely concrete. It's not something that's just you're going to read about it and it doesn't apply to you. This is actually something that will come into effect and that will apply to you, if actually you submit an application under those categories. I hope that is actually sufficient. If you guys have any question, don't forget, follow our channel, because we actually always submitting some information about immigration news, immigration tips as well. Don't forget, my name is Annie Koloko. I am an immigration attorney. And obviously, don't forget to click on the notification. That way you receive the notification. And I will see you soon. Thank you again. Be safe. Thank you. Goodbye.